Hi everyone, welcome to NLTI's official YouTube channel for your CLAT and ALET preparation. I'm Manish Gupta, the founder of National Law Training Institute and a recent graduate from the National Law School of India University, Bangalore. NLTI is conducting this moot court competition exclusively for class 11 and 12 students to give them an insight into how mooting works when they enter law school. We had a total of 54 teams who registered for this competition. Out of these 54 teams, around 40 teams submitted their memorials. After 20 preliminary rounds, top 8 rounds, that is quarters, then semis for top 4 teams, we now have our finalists in this room. That is the WHO versus PCRC. Let me quickly introduce our judges for this round. We have Tanvi and Sohina, both recent graduates from the Nalsar University of Law, Hyderabad, who will be judging this round over the next 30 minutes. Uh, Extensions could be granted based on requests, but such requests need to be made before your speech is completed. After you have completed your speech, no extension request would be considered. All the best. Thank you so much for participating in this competition. May the best team wins. I think Sohina is having some issues. Let's just wait till she rejoins. In the meanwhile, you can quickly tell Tanvi your time allocations so that she could keep a note and inform you accordingly.
Hi everyone, as I understand, who is the plaintiff side and the PCRC for the defendant side.
Hello, Tanvi.
Hi.
Is it okay if I'll call you Tanvi?
Yeah.
All right. So, Tanvi, we are from the plaintiff side.
Okay.
So, I'll be speaking on issue one for 6.5 minutes, and subsequently, my co-counsel will be speaking on issue two for the another 6.5 minutes.
Okay.
And then we have reserved 2 minutes for rebuttals.
Okay.
All right.
Is there any disturbance in voice, or is just I can't hear it properly?
There is indeed some kind of disturbance there.
Yeah, I think. Can you hear me properly?
From my side,
Okay. Yeah, I think I'm not sure like which mic is that coming from.
Am
But
I
yeah,
audible
sure. So 6 months.
to everyone?
Yeah, you're right.
Thank you.
yeah, it will be fine. I'm very sorry.
Yeah, I think it's fine now. 6.5 for the first, 6.5 for the second speaker, and 2 minutes for the rebuttal.
Yeah.
Okay. And for the PCRC defendants?
Hello, everybody. The first speaker will be speaking for about 6 minutes on issue number one, which will be further continued by my co-counsel, who will be speaking on issue number two for 7 minutes, and we have reserved 2 minutes for rebuttal.
Okay, good. I have noted down the time allocations. Soina, do you want to ask any other preliminary questions, or we can begin with the plaintiff? I think there's some network issue from her end. We can just wait for a minute. Sorry?
So, Sohina, you can keep your video off. Try doing that. It's better now. Yeah.
It's better now. You can put it in chat box if you can start the round. Also, do you guys want me to tell you any timestamps in the chat box, or like how much time is remaining, or you'll be keeping the count of time yourself?
That would be great if you can do that. If you can warn us just a minute before the time is about to end.
Okay, I'll do that. I'll
Thank
put
you.
it in the chat box, or if I'm like asking a question, I'll just tell you right there.
Yeah, thank you so much.
Tanvi, I think we can start.
Okay. Just give me a minute. I'll start timing myself. Okay, plaintiffs can start whenever. I'll accordingly start the time.
Shall I proceed? All right. Greetings, Your Lordship. I am one of the two counsels from the team The Who, appearing on the behalf of the plaintiffs Manar Bandit and 9 other students of NLTI school in suit number 12 of 2026 before this civil court in the matter of Manar Bandit versus Matchday Merchandising Company. So, if it pleases the court, I shall begin with my submissions. Much obliged. Your Lordship, the defendant seeks to escape liability for defective goods by invoking a single defense that our lead plaintiff Manar is a minor. So it is the plaintiff's humble submission that this defense is simply not available to match day for three independent reasons, in which I'll be first arguing that institutional consent was obtained, then that match day had actual notice of the minority, and lastly that match day is bound by doctrine of approbate and reprobate. So, proceeding with our first line of arguments, I would like to draw your lordship's attention to the very declaration clause that the defendant drafted and inserted in its own Google form. I plead the bench to refer to para 5 of the moot proposition, and I quote the clause. I confirm that I am 18 years of age or am placing this order with the consent and authority of my parent, guardian, or institution. Your lordship, Matchday constructed two alternative routes for a valid contract or a valid order. The first was majority, the second was institutional consent. So Manar, though couldn't satisfy the first, completely adhered to and complied with the second, and I would plead the bench to refer to para 3 of the moot submission now. Here we can see that, however, the students, and I quote, however, the students had informed Miss Dakat, the teacher in charge of the sports club, that they intended to wear matching jerseys and take photographs. Miss Dakat replied on the class WhatsApp group, no problem, but please do not collect money in the school's name. Now, my lordship, our plaintiff first approached the teacher in charge of the sports club, Miss Dakat, direct representative of the NLTI school, that is the institution in question, and sought permission for the conduct of the event, to which Miss Dakat affirmatively replied, granting permission for the conduction of the event while imposing a single caveat, which was to not to collect money in the.
Counsel, just a question here. Are you arguing that the plaintiff here, the person who was 16 years of age, was acting as an agent on behalf of the institution?
No, no, absolutely not, your lordship. He was acting in his independent capacity, and he is the party itself in the contract.
So a minor can be a competent party to the contract. Are you arguing that?
Yes, lordship. A minor cannot be a competent party in the contract, but as I reiterated, that match day itself constructed two valid routes to a valid contract. First was that the person must have attained 18 years of majority, and other than that, it was that they should have obtained consent from their guardian or the valid institution. So what I am arguing is that Manar obtained consent from the regarded institution, which was NLTI school, through the agent Miss Dakat, who was the direct employee of NLTI school and responsible to the same.
Then, counsel, why eventually the parents filed the suit and not the institution?
Because, your lordship, the institution was only concerned with granting the authority, and then granting the consent, and then parents in behalf of the students filed the suit because they were the one who paid for the money.
So how many parties we are saying? Like I'm not getting clarity.
There are only two parties, your lordship. First is Manar, whose suit was filed through their parents, and second is Matchday Merchandising Company.
Okay.
Yeah. Shall I proceed with my submissions? Yeah, much obliged. So, your lordship, the institution in question here is the NLTI school, whose consent was obtained. Manar obtained the school's direct consent of the direct school's representative, which was Miss Dakat, and Miss Dakat did not consent in her capacity as a representative of the unregistered club, but in her official capacity as the teacher employed by and answerable to the NLTI school. So Manar, as directed by the Matchday Merchandising Company, had the direct consent of the institution, the authority that was concerned. And even if your lordship were to set aside the declaration clause entirely, Matchday's conduct independently disentitles it from raising minority as a defense, because Manar entered his age 16 in the column of the Google form. He didn't conceal his age, he didn't misrepresent his age. So, your lordship, this wasn't the case of a minor misrepresenting his age fraudulently. It was a minor who transparently disclosed his age and proceeded on the strength of the alternative route regarding the institutional consent that was given by the Matchday Merchandising Company itself. And despite this actual and documentary knowledge of Manar's minority, they proceeded with the order, with the knowledge of and even recorded in their system that our lead plaintiff Manar was 16 years old. Now, your lordship, turning to the fundamental fairness that the defendant seeks to ignore is the doctrine of approbate and reprobate.
Counsel, on the second prong regarding the other party having the awareness regarding Manar being 16 years of age, I just want to ask, are you aware of the principle that minority can not be used as a sword, but only can be used as a shield?
Yeah.
So here, as a minor, if you're coming to the court, what you're using that as a sword and not as a shield. You are basically asking for benefits now. for a contract which did not even fulfill the basic requirement of competency?
Your Lordship, I beg to differ. I beg your finest pardon, but I believe that the direction of the doctrine matters. And the minority doctrine exists to protect minors from being sued upon for enforcement of obligations that they cannot perform. It was never intended to protect adults being sued by the minors. So, even if we'll go by the judgment of Mori Bibi versus Dharmodas Ghosh, the Privy Council in that case, the concern of the Privy Council was protective towards the minor. So, it was shielding a minor from being held in an obligation that they cannot perform. So, here saying that the contract is void, it will be shielding match day from undertaking the obligations that they were supposed to undertake. So, Your Lordship, it is not Manhar being asked to perform an obligation he cannot discharge. It's the minors, it's the plaintiffs who are coming to this honorable court for seeking relief and enforcement of their rights. And what Matchday is trying to do instead is the exploitation of the minors through unjust enrichment, disguised as a protective doctrine under Mori Bibi versus Dharmodas case.
Just
Uh,
so
yeah,
sorry to interrupt you. I couldn't put it in chat, but 6 minutes 30 seconds.
yeah. All right. Now I rest my submission, Your Lordship, and I'll invite my co-counsel to address issue two. Thank you.
Okay. Just before your co-counsel begins, I'm not able to put it in the chat. Is there any settings which can be changed, Anish?
There should be an option of private chat, or on the right
Okay.
hand side, bottom right, there should be an option of chat.
Okay. Understood.
Yeah.
Okay. The
May I
second
take
counsel.
one?
Yeah.
Greetings, Your Ladyship. May it please the court, I am the second counsel from the team The Who, appearing on behalf of plaintiffs. I'll be assisting the court with applicant's last submission, in which I'll address issue 2, which concerns whether Matchday Merchandising Co. is exclusively and entirely liable for the fundamental breach of contract and whether plaintiff's own conduct in any manner disentitles them from relief. Your Ladyship, the short answer to both of this question is that Matchday breached every material specification of this contract and plaintiffs did nothing wrong for three independent reasons, which are: first, fundamental breach under Section 37 of ICA; second, quality assurance was a contractual term; and third, lastly, not a valid acceptance under Section 42 of SGA Act 1930. If it may please the court, I may begin with my submission. Proceeding with our line of argument, I would like to draw court's attention towards the very fact that Matchday Merchandising is exclusively liable for the fundamental breach of contract under Section 37 of Indian Contracts Act 1872, which mandates that parties must perform their promises substantially as agreed. Additionally, the legal principle, as affirmed in Value versus Whip, says that in a sale of goods by description, there is an implied condition that the delivered goods must exactly match the description provided. Now, coming on to defendant's promise, recorded in their own confirmation email, I plead the bench to refer para 8 from the moot proposition. And I draw your ladyship's attention to the exact wording. Premium dry fit jersey, Striker X branded, stitched crest, heat press name and number. And what was delivered, your ladyship? Please refer to para 14. Please refer to para 14. No Striker X branding, a printed crest, not stitched, fabric thinner than was actually advertised, loose threads on two jerseys, color that faded in the very first wash, and misspelled names. Your ladyship, not a single material specification here was met. This is a wholesale failure of performance from defendant's side,
Counsel,
and
just
that,
Council, I have a question. Is it okay if I proceed, Tanvi? You say that it's completely and exclusively the liability of the defendant here, but don't you think the jerseys being worn, photographed, and used for basketball, as well as washed after using those jerseys, don't you think this was there was a sort of duty on the plaintiff to mitigate the losses which they're now claiming, and part of the damage is contributed by the plaintiff himself?
Your ladyship, I would like to bring it to your notice that firstly, jerseys being washed and being faded does strengthen our case instead of weakening it. It shows that it was latent effect that was shown later, that came out later. And jerseys washed is a thing that is very obvious that would a plaintiff, any plaintiff would do with jerseys. Secondly, jerseys worn in an event that was made for that very event. The consent, the acceptance was not an informed one here, rather the one where they were compulsed by the very act of Matchday Merchandising Co., who delivered the jerseys on the very day of the event held. So the photographs taken or playing basketball game is an effect that was foreseeable when the contract was formed and not an ultra wires to contract.
Okay, please proceed.
Uh, yeah, this is a wholesale failure of performance from defendant side, and Matchday simply failed to deliver goods exactly as provided in the description of same. Additionally, quality assurance was a contractual term, not a disclaimer, and the proposition records it precisely. Kindly refer to para 11 and 12. Manhar explicitly reiterated that quality is the very essence of contract numerous times, and I quote, "Please do premium quality only. We are paying full, not cheap." And each time, Matchday affirmatively assured that quality won't be compromised, which they clearly didn't stand on. In Baldry versus Marshall 1925, the court.
If I, sorry to interrupt, if I may
Yeah.
take you to the paragraph 12 of the moot proposition, the last line says the representative responded, "Will manage best possible, don't worry," which means they never gave a assurance that the quality would be what you are asking, but they'll try their best to give that kind of quality. So, what's your stance? And you never rebutted it later.
Your leadership in that very paragraph, defendant noted quality would be same. Quality would be same. Only the striker X branding would be revealed. So this is defendant's dichotomy that she is reiterating same. She is providing different stance in a very same paragraph. This is a confusion delivered by defendant on their own, and plaintiff Manohar here has no responsibility over it. If I may, in Baldry versus Marshall 1925, the court held that where a buyer states a specific purpose and receives an assurance, that assurance is incorporated as a condition. So, considering the legal principle that an assurance given directly in response to an explicit condition becomes a term to the contract, Matchday gave the assurance which Matchday itself failed to meet. Hence, it is evident that a fundamental breach of contract occurred on the side of Matchday Merchandising Co. Lastly, your ladyship, I'd say that final argument of defendant is the most cynical. That just because students simply wore jerseys for 20 minutes, they accepted defective goods and cannot complain about that. Your ladyship's acceptance in law, as prescribed in Section 42 of Sales of Goods Act, requires three essential criteria to be fulfilled: intimation to the seller, a voluntary and informed act, and a lapse of reasonable time without complaint. None of these three criteria, I repeat, none of these criteria were fulfilled. Firstly, there was no intimation of acceptance. Manar complained the very next morning, which was 15th of June. This is literally opposite of intimation. Secondly, the acceptance was not voluntary, it was compulsion. It was under compulsion, driven purely by exigency, under the circumstances that were in turn created by matched merchandising on their own. This simply cannot constitute an acceptance. Lastly, your ladyship, consider what created the compulsion. Matchday's own breach, delivering the defective goods on 14th of June for an event that was held on that very day, left students with no time to procure alternatives. A party in breach cannot benefit from compulsion their own breach created. I would like to raise my submission here because I believe I have lapsed my time.
I know you have completed your time. I just had one more question here. You mentioned in, I think you're the first prong of submission regarding Section 37 of ICA, where you mentioned that the substantial compliance with the
Uh, I'm not able to hear you, your ladyship. Am I the only one? Hello.
No, the video is paused.
Okay. Yeah. The video is still paused, right?
Just wait for a second. Tanvi is rejoining. So sorry for the inconvenience, guys. This is a
Yeah.
new platform that we're all trying to navigate. First time. Yeah.
Yeah, am I audible now?
Yes, your ladyship.
Yeah. I was asking question regarding your first prong. You made first prong regarding section 37 of the Indian Contract Act, and you mentioned that substantial compliance or substantial fulfillment of the contract would not amount to a breach. So don't you think in this case there was substantial compliance with the contract? T-shirts were delivered, they were even used for the purpose they were meant to eventually. So there was substantial compliance, and that doesn't amount to breach. There were defects here and there, but wasn't section 37 precondition fulfilled?
Uh, your leadership, this is, I would like to bring this to your notice. While they wore the jerseys, they did not wear as they envisioned it to be. Imagine wearing jerseys with your own misspelled name. Imagine wearing jerseys with some standard quality goods. This is not what they entered in contract for. This is what not the promise was made for initially. Additionally, I would like to quote a very famous judgment here, Jarvis versus Sons Tools Limited, where I quote one, where this is a landmark judgment where it was established that a plaintiff can recover financial damages over mental distress, frustration, and disappointment if the primary and express purpose of the broken contract was to provide enjoyment, relaxation, or peace of mind. This is exactly what was breached here.
Okay, okay. I just had one. Anish, do we have time? I just had one more question for the
Sure,
first.
sure. No worries.
Regarding first speaker who made submissions on issue one, you mentioned that your main argument is that the person here, though the plaintiff is minor, but they were consenting with the consent of parents or guardian or the institution protected. But are you aware of Section 11 of Indian Contract Act, which says that a minor can't enter into the contract, which means there is no leeway period, or the statute has not given you scope that okay, you take consent of your institution or parents or guardian and then enter into a contract. So where are you drawing the authority there?
Uh, your ladyship, first of all, I beg your finest pardon for addressing the benches, your lordship, in my previous submissions. So, your ladyship, I asked this honorable court to step back from the individual provisions and precedents and consider what this case is in its heart. So let's consider this scenario. I know that the law doesn't have a very good taste for speculations and hypotheticals, but let's just consider this scenario where the defendant's position is claiming that if the contract will be void, then a vendor could contract with a minor, it can take full payment, it can deliver substandard goods, and walk away without any consequence, citing the very minority it was aware of throughout this process. So, your ladyship, if we'll go by the very crux, the very motive of the Section 11 of the Indian Contracts Act, even if read with Mori Bibi versus Dharmodas Ghosh, it exists to protect minors from exploitation and unjust enrichment. And to say otherwise and consider this contract as null and void, it will be the direct antithesis of protecting the minors and exploiting them with unjust enrichment by matchday merchandising company. So it will be great miscarriage of justice. So the very motive of Section 11 and read with Mori Bibi versus Dharmodas Ghosh case is not getting fulfilled if we consider this contract as null and void.
So do you agree that the text of Indian Contract Act does not allow this contract which was entered by plaintiff, and we only have to rely on the spirit of the law? The text of the law doesn't allow it.
Your leadership, it is disputed, yes, from our side.
Okay.
Yeah.
Thank you. The defendants can start now. I just confirm the time allocation was 6 minutes and 7 minutes, right? Okay.
Right. May I begin, Your Ladyship?
Yes, please start.
May it please the Honorable Court, appearing as co-counsel for the defendant, Matchday Merchandising Co. With the kind permission of this honorable bench, I seek to proceed with my submissions. Thank you, Your Ladyship. My issue before this honorable court is whether a valid and enforceable contract arose between the students and Matchday Merchandising Co. It is my respectful submission, Your Ladyship, that no valid and enforceable contract arose between the parties. At the outset, I shall advance three principal arguments. First, the order was placed by a minor who lacked contractual capacity under Section 11 of the Indian Contracts Act, rendering the agreement void ab initio. Second, the plaintiff possessed neither parental authority nor institutional authority to place the order on behalf of the other students or the school. Third, the subsequent WhatsApp messages and email confirmations cannot cure the original defect of incapacity or transform a void agreement into a valid contract. I shall address these submissions in turn. First, the agreement is void ab initio as it was entered into by a minor. Your ladyship, excuse me, your ladyship, Section 11 of the Indian Contracts Act provides that only a person who has attained the age of majority and is of sound mind and is not otherwise disqualified by law is competent to contract. The law on this issue has been conclusively settled by the Privy Council in Mohari Bibi versus Dharmodas Ghosh, wherein it was held that an agreement entered into by a minor is void ab initio. In other words, it is void from its inception and creates no enforceable contractual obligations. Therefore, Your Ladyship, the very person who initiated the transaction lacked the legal capacity required under Section 11. The plaintiff seeks.
With counsel, now you are arguing the incompetency of the plaintiff, but you were very well aware of this incompetency while you were entering into the contract. Then why did you enter into the contract in the first place?
Much obliged, Your Ladyship. I would like to answer that by quoting again the landmark judgment of Mohari Bibi, which says that an agreement with minor is void, irrespective of whether the other party knew of the minority. Capacity is a matter of law, not knowledge, and any subsequent communications cannot cure the original incapacity of a minor. A void agreement remains void, irrespective of performance.
With counsel, there is jurisprudence even after Mori Bibi, which says that the other party can't take advantage if they were clearly aware of the minor's age while they were entering into the contract. Now you're raising it just to take the advantage while you were well aware while entering into the contract.
Right, Your Ladyship. For that, I would like to answer that the defendant took reasonable precautions to prevent this. The Google form had a declaration which says that the students have to be, if I may refer to paragraph 5 in the moot proposition, it says that I confirm that I am above 18 years of age, or I'm placing this order with the consent and authority of my parent, guardian, and institution. So even if the plaintiffs entered the real age, which was 16 years, it was kindly and rightly assumed by the defendant that they must have had the institutional or parental authority because they again ticked the declaration box saying the same.
Counsel, sorry to interrupt you. Just wanted to clarify if your client did any due diligence to check if there was parental authority or authorization. Were they able to do that before they proceeded with the contract?
With due respect, Your Ladyship, I would like to state that there is no current statutory provisions that require the commercial entity to do a thorough check before entering into a contract with the minors. To hold otherwise would place an unreasonable burden upon the commercial entities to verify each and every detail before entering into a contract.
Okay,
May I
you can
may I
proceed.
proceed?
Yeah, yeah.
Thank you so much, Your Ladyship. The plaintiff seek damages for alleged. I'm so sorry. The plaintiff seek damages for alleged defective performance. However, damages are remedies arising from a legally enforceable contract. The plaintiffs themselves acknowledge that the agreement is void ab initio. Having accepted that position, they cannot simultaneously seek contractual remedies flowing from the same argument. A party cannot both affirm the voidness of an agreement and simultaneously claim contractual relief under it. Further, the doctrine of unjust enrichment cannot be used to indirectly enforce rights arising out of a wide agreement. The defendant.
Counsel, if I could interrupt you once more, could
Right.
you list out the essentials or the ingredients of Section 65 and in what cases is restitution awarded under unjust enrichment?
So under section 65 of the Indian Contracts Act, it may I please take a moment to refer to my notes?
Yes, please.
Um, may I proceed? Section
Yes, please.
65. Thank you, Your Ladyship. Section 65 of the Indian Contract Act holds restitutional remedies only if the contract, which was originally entered believing that it was void and subsequently believing that it was valid and subsequently turns out that it wasn't. It has to be discovered. It has to be established that it was later discovered that the agreement was void, which is not the case here because. in this particular case, the contract was void ab initio. So, respectfully, the application of Section 65 stands null and void.
How is this not a case of discovered to be void? You clearly thought while you were entering into contract performing the obligations from your side that you were actually performing the obligations of a valid contract. Later on, now you claim that you figured out there was no institutional consent or there were no parent or guardian consent. So isn't it like you discovered it to be void and hence the restitution should apply?
While I may agree with that fact, Your Ladyship, although I would like to kindly reject the fact that the plaintiff should be provided restitutionary benefits solely because the defendant had to incur numerous costs from manufacturing, from to delivering the goods. So to say that the plaintiffs were unjustly enriched, so to say that the defendants were unjustly rich, it is not a case where the defendant has kept all the money and has left the plaintiffs with nothing. The plaintiffs did actually have the jerseys with them, and they did everything. They used them for its very purpose. So may I proceed?
So, counsel, if we cut down on the manufacturing costs, etc., so do you think you are in a position to repay the rest of the money back?
I would like to disagree, Your Ladyship. I believe that the restitutionary principles would only be applicable if the contract was valid. And also, when we speak about this case, this is not about. It may seem like this is a case about whether it's being unfair towards the plaintiff, but the law does not speak about the principles of fairness. It speaks on the principles of facts, grounds, evidences, and statutory provisions. Right. Um, May I proceed, Your Ladyship? My second argument is that the plaintiff possessed neither parental nor institutional authority. My second submission is that the plaintiff lacked authority to place the order on behalf of either the school
Counsel,
or the participating.
on my clock, it's 8 minutes already, and I gave you a heads up at 5 minutes when it were done. Since your allocated time was 6 minutes, I'm just letting you know the times.
Unless the honorable bench has any further questions, those are my submissions. I now seek to yield the floor to my learned co-counsel for issue number 2. Much obliged, Your Ladyship.
Leadership, with respect, may I request a brief extension of 1 minute?
The
You can seek one when you are running out of time later, but for now, please stick to the time that you've been allocated.
Sure, Your Ladyship. May it please the court, my name is Ms. Ananya Hangri, appearing as counsel for the defendant, Mazda Merchandising Co. My learned co-counsel has already addressed issue 1, that is the invalidity of the contract on the account of the plaintiff's minority. With the court's permission, I shall now address issue 2. However, I wish to make it clear at the outset that this submission is made entirely without the prejudice to a primary case in issue 1. Assuming only for the sake of the argument that a valid contract did exist, on that assumption, the counsel shall demonstrate that the defendant cannot be held singularly liable as the plaintiff's own conduct at every stage of the transaction contributed to the very losses they now seek to recover. For the convenience of these proceedings, may the counsel refer to your ladyships as such? Much obliged, your ladyships. Before I proceed, allow me to set out the structure for my submissions. I have divided my arguments fourfold, and these are: first, the absence of Striker X brand tag; second, the acceptance by conduct; third, the doctrine of approbation and reprobation, or more so commonly known as doctrine of election; and fourth, the claim for mental harassment and social embarrassment, together with the plaintiff's failure to mitigate. I shall address each in turn. Your Ladyship, if I may draw your attention to paragraph 12 of the proposition, and I hope your Ladyships are following me on this. The sequence of events of 10th June is as critical. On that day, Matchday's representative messaged Manhar stating, and I quote directly from the proposition, Striker X tags are delayed because of huge victory demand. We can either delay delivery by 5 to 6 days or send the same material without the outer brand tag, quality same. Your Ladyship, two things must be noticed. First, the defendant was transparent. It disclosed the supply constraint beforehand and offered not one but two clear options. Secondly, it came with an assurance of quality same, meaning the material would remain unchanged. The only thing varied here was the outer brand tag. Now, if your Ladyship would turn to the same paragraph, Manhar's response was can't delay need before Friday, but don't compromise quality. And the representative responded, will manage best possible. Don't worry. Your Ladyship, Manhar made a choice. He chose immediate delivery. He chose speed under Section 62 of the Indian Contract Act. Once parties agree to alter the term, the original obligation stands discharged. Having accepted timely delivery in place of the brand tag, the plaintiffs cannot now seek enforcement of the very term they agreed to waive. On the topic
So,
of
Council, I agree that there was alteration with respect to the availability of the brand tags, but there was no consent on alteration with respect to the quality. Like they did say that they need the same quality even if you can do away with the tags. So how's there meeting of minds with respect to alteration on the fabric?
Your Ladyship, the defendant, the Matchday Merchandising Co. said they will manage best possible. It was a guarantee of quality. With respect, this if they may argue that this is a guarantee of quality. However, this argument cannot stand because these words were spoken in the context of a supply constraint that the petitioner had already accepted. It was at its best a best efforts assurance, and it was not an absolute guarantee of the original specification. And however, does it makes it legally untenable or
Sir, but
commercially?
here, since you refer to the mood problem, I again take you back to the paragraph 12 you referred. In the second line, it says that we can either delay by 5 6 days or send the same material without the outer brand tag, quality same. You yourself said either take it late or take it with the same quality and the same time, but just without the tags. And then you are mentioning the vague phrase of I will manage best possible. So at best, we can say that there was vagueness with respect to the quality, and if there's vagueness, there's no successful alteration, and we go back to the original contract, which asked for the premium quality.
So, leaderships, in this is informal communication, and there's no formal requirement. And also, the Manhar accepted that no tag would be needed, but the defendant still had to deliver, and they said will manage best possible. This comes as a reading of a specific uh, best possible outcome and assuring the plaintiff that will try its best. However, there's not a guarantee on it. So this is commercially it's a renowned term to suggest that there may be some changes, but it will try its level best to assure of that. May I proceed, Your Ladyship? Okay. So, on Your Ladyship, I now turn to my second argument, which stands for acceptance by conduct. If Your Ladyships are following me, I wish to walk through the code through the precise sequence after the delivery as recorded in the proposition. If I may draw Your Ladyships' attention to proposition to paragraph 13, 14, and 15 of the proposition, these three paragraphs tells us everything we need to know. Paragraph 13 records that the jerseys were delivered at the school gate on 14th June 2025 at 3:40 p.m. Manhar collected the parcel and paid the balance amount of 6,500. No teacher was present. However, paragraph 14 records that upon opening the parcel, the students found the defects. No striker X tag, printed crest, thinner fabrics, loose threads, and misspelled names. And paragraph 15, Your Ladyship, this is the critical paragraph, records that despite knowing these issues, the students wore the jerseys for approximately 20 minutes, took photographs for Instagram, and two students played basketball while wearing the jerseys, and one jersey was later washed at home. Your Ladyship, let me apply Section 42 of the Sale of Goods Act to these facts. Section 42 provides that
Counsel, if I may interrupt you, and before you proceed with the rest of your argument, if you could uh, look at paragraph 10 of the moot proposition. Here, your client himself or herself confirmed that the final spelling before 8 p.m. is to be confirmed and that will be sent to the printer. And even when Manhar replied at 7:56 p.m., he said, done printing tomorrow, balance on delivery, which is paragraph 11. Yet you see that in paragraph 14, the names are misspelled. So even after the merchant himself agreed to the names and sent them for printing, they were still the wrong names printed. So how do you defend your how do you plan on defending your client here? The defects were very much from the beginning and not something that could be attributed to the plaintiff here.
Your Ladyship, before I begin, may I request an extension for 1 minute? Okay. So firstly, there was the duty to mitigate, and also if the defects were noticed, the reasonable assumption the defendant was the plaintiff could have rejected the goods then and there itself and could not have paid and should not have paid the balance of rupees 6,500. And however, they did proceed with that. And in the Supreme Court case of Murlidhar Chiranjilal versus Harish Chandra Dwarkadas, the Supreme Court held that claimant cannot recover for the losses at their own conduct or cause or made worse for their own after the breach. So
Council, on that note, you would also notice that when the jerseys were washed later, which I agree would be a fault on the part of the plaintiff, the material bled and the color came out, which means that there was an original defect in the jersey itself. And at the same time, was there any time for the plaintiff to actually discover those defects? Because, as far as I know, time was of essence to this contract, and they definitely said clearly that they wanted the jerseys on time, and there was no time to delay or postpone their event, which is why they had no choice but to wear those jerseys. Then, what opportunity did they have to point out the defects and reject the delivery?
Your Ladyship, one of the jerseys which was washed at home did bleed, and however, this cannot be contributed to the entire falsity of the entire goods delivered. In commercial contracts, there may be specific deviations from what the goods were actually promised. However, the plaintiffs were given enough opportunity to reject the goods because they accepted and paid the balance. This was accepted, and this is a first act of acceptance, and because they paid the rupees 6,500 balance without protest, and there was no compulsion whatsoever on their half because they could have rejected the goods. Secondly, your ladyship, the buyer who rejects the goods returns them, but they do not wear them, and they do not play basketball in them, and they do not post photographs on themselves in Instagram, and they certainly do not wash them at home. So every single act that the plaintiffs perform after opening that parcel is an act of ownership and not rejection. And third, the jerseys were held by the students overnight without a word of rejection, and only they raised the issues the following day as recorded in paragraph 16. May I proceed with my submissions, Your Ladyship?
Yes, please.
Okay, so that brings me to my third argument, the doctrine of election, or what is known as in law as approbation and reprobation. The Supreme Court in R.N. Goshan versus Yashpal Dheer of 1992 of held, and I quote, a person cannot at one time say that a transaction is valid and thereby obtain some advantage to which he could only be entitled on the footing that it is valid, and then turn round and say it is void for the purpose of securing some other advantage. Your Ladyship, if I may draw attention to what the plaintiffs actually said, they wore the jerseys for the very occasion they were purchased for, as recorded in paragraph 15 of the proposition. They took Instagram photos, they played basketball, they derived every benefits those jerseys could provide, and only thereafter, the next morning, as paragraph 16 records, did they demand a refund. Having extracted every benefits, the plaintiffs cannot now turn around and say that the delivery was defective for the purpose of securing a full refund of 11,500. That, Your Ladyship, is precisely what the approbation and reprobation principle prohibits in under R.N. Goshen. I now turn to my fourth and final argument, the claim for rupees 10,000 as compensation for mental harassment.
Council,
If Your
can you
Ladyship,
quickly summarize? You're already 10 minutes, 48 seconds.
okay, Your Ladyship. So, if I were to briefly summarize the defendant's position on issue two, the brand tax was the plaintiff's own choice. There's a variation, there's binding under section 62, and the doctrine of approbation and reprobation under R.N. Goshen bars them from seeking a full refund. And as for the claim of 10,000 in mental harassment falls both under Addis versus Gramophone case and Ghaziabad case of 2003 and section 73 of the Indian Contract Act. So the facts that students brought them the embarrassment upon themselves and what they suffered. The defendant accordingly cannot be held singularly liable. So under this, unless this honorable court has any further questions, this concludes the oral submissions on the behalf of your defendant. Much obliged, Your Ladyship.
We can start with the rebuttals. Both the teams have 2 minutes.
Shall I?
Yeah.
First of all, I beg your finest pardon again, your ladyship, for wrongfully addressing the bench. And secondly, my learned friend mentioned doctrine of approbate and reprobate. So Your ladyship, I want to bring it to your attention that this is the exact fundamental fairness that the defendant seeks to ignore. And as he mentioned, that doctrine of approbate and reprobate is a well-established principle as established by our Honorable Supreme Court in Aaron Gosain versus Yashpal Deed. I quote the judgment that a party cannot accept the benefits of a transaction and subsequently reject the burdens of the very same arrangement. So, going by the same fact of line of fact, that reiterates that Matchday cannot accept the benefits of a minor saving and then reject the burdens of providing a quality product, and then claiming that the contract was invalid. So, to sum it up, your ladyship, what Matchday is doing is blowing hot and cold at its own convenience. So, they cannot blow hot and cold at its own convenience here. Secondly, your ladyship, let me come to the very ratio decidendi of Mori Bibi versus Dharmodas case, as my learned friend mentioned. So the very ratio decidendi, the very rationale behind that case is to protect minors from unjust enrichment, to protect minors from exploitation. What will happen if we'll consider the contract void ab initio in this case is exactly the antithesis of the case of Mori Bibi if read with section 11 of the ICA. And my last argument will be my learned friend suggested, and if section 11 were absolute in the sense my learned friend suggested, that will mean that nothing whatsoever follows once an argument is found to be void and void for minority. So your ladyship, section 65 of the same act would have no field of operation in the minority cases. So I see a legal fault, a clear legal fault in quoting section 11 and section 65 in the same line of argument. There is a clear contradiction between the two cases of line. So either they are trying to find a loophole by saying that if this doesn't apply, then this does, or they are just trying to escape the breach of liability and claim that the contract was invalid by bluffing. Now, my lordship, I beg your finest pardon. Now, my ladyship, I'll give the rest of the time to my co-counsel.
You've already done with 2 minutes 12 seconds.
Can I seek a extension, your ladyship?
There are no extensions rebuttals generally, but sure, 30 seconds if you
Okay.
I would just like to bring it to your notice that my learned opponent counsel just had this fundamental flaw in their reasoning that the plaintiff should have accepted, the plaintiff accepted the goods while after paying the balance amount of 6,500 rupees. I would like to bring it to your notice. How can our plaintiff, without opening the box, without knowing the defects, would have rejected the goods here? The balance amount was a transaction that was pre-decided and that plaintiff was bounded by it.
Defendants can start with the rebuttal. You again have 2 minutes.
Okay, Your Ladyship, on the count of what my learned counsel said, that the defendant is running hot and cold. So, in the starting of my speech, I said that this is a standard without prejudice argument. Courts, they routinely entertain alternate and inconsistent pleadings all the time. So the defendant's primary submission is still that no valid contract existed. However, should this honorable court were to find otherwise, the defendant submits in its alternative that even on the assumption of a valid contract, it cannot be held singularly liable. So the two submissions which the defendant made, they operate on two different footings and they do not contradict each other. They are sequentially ordered defenses, Your Lordship. And as to what my second learned counsel said on the act of paying the balance of 6,500 rupees, the event could not be postponed, yes, but accepting the defective goods was entirely the student's choice. They could have declined the delivery, they could have attended without jerseys and sought the alternatives from another vendor. Under section 42, this accounts for a deemed acceptance by them paying the balance amount of rupees 6,500. That also concludes the rebuttal round for the defendant.
I think with this we conclude this round. Congratulations, you're done with it finally.
Okay, so we will give 5 minutes to the judges to decide the verdict, and then after 5 minutes, we'll start with the feedback. Post that at 4:30, 4:35, we'll start with the award ceremony. Okay, you guys can stay in the call. Tanvi, you can decide with Soina and let me know before the feedback. Hi everyone. So there is a slight change of plans. I have received a word from the judges that the feedback needs to be a bit personal, and so it's not a good idea to have it over a stream that is being live streamed over YouTube. So we will reserve the feedback for now, and we will connect you with the judges later on. Uh, I am compiling all the results and the awards that have to be given out to all the teams. So I request the teams present in this call to leave the meeting right now and join the YouTube link at 4:30, a couple of minutes later, so that I can uh, keep my things in order and announce the results in the YouTube live. So the WHO and PCRC, you leave this particular call and join the YouTube link where we will be announcing the results. And for the feedback, I will connect you with the judges again later.
All right. Thank you.
Thank you. Hi everyone, welcome back to NLTI. Sorry to keep you all waiting. So drum rolls, the final moment is here after some 55 grilling rounds that saw participation of over 40 teams in the NLTI Moot Court competition 2026. We now have the final results in hand, not just the final winner awards, but we will also be announcing the distinction awards and the awards for best memorial. So stay tuned for another 5 minutes. I will take you through it in detail. But yeah, congratulations to everyone who participated in this competition. The very fact that you guys are still in class 11th or 12th, or have just cleared class 12 and will be joining law schools this July, and participated in this competition even before joining law schools, is something that you should be very proud of. The skills that you have presented, the argumentation techniques that you have all engaged in were exemplary, were extraordinary, and we do not have mooters even in law schools who match the level of quality that we saw in this moot court competition. This is the first edition, but we are sure that seeing the success of this one, we will keep on bringing this moot court competition every June, every year from now on. Thank you so much, everyone, for participating, for trusting us. If you're a CLAT aspirant, now you have seen the level of professionalism and quality that we maintain at NLTI, and we all encourage you to trust us again with your CLAT prep if you are one of the CLAT 2027 or CLAT 2028 aspirants. Okay, so I will not keep you waiting anymore. Let me quickly take you to the results of the NLTI Moot Court competition of 2026. We will first start with the distinction awards. So the first award that we have with us is the Distinction Award for Best Legal Acumen. This award awards the team that portrayed the best knowledge of law and facts. And the award for the Distinction Award for Best Legal Acumen goes to Team Aerosmith. And the members of this team are Vanshika Rathi and Yashwardhan Singh. So congratulations to Team Aerosmith for winning this award. The second distinction award that we have is the Distinction Award for Ingenuity and Ability to Answer Questions. This team got the highest score in this particular scoring head based on the preliminary scores. And the award for this distinction award goes to Team Queen. The member of this is a single member team, which makes it even more exemplary, and the member is Hagreev Devanathan. One more thing that I would like to share here is that teams Aerosmith and Queen missed quarterfinal breaks by a whisker. Both these teams were placed at position, I think, 9 and 10, and they equally deserve to be in the quarters. But yeah, sometimes it's just a point decimal that makes you miss or hit or miss the quarterfinalist position. So the second award goes to Team Queen. The third award that we have is for Best Courtroom Advocacy Award, and the team that takes this award is One Republic. We have Akanksha Londe and Abhinav Kumar winning this distinction award for Best Courtroom Advocacy. The fourth award that we have is the Distinction Award for Best Organization and Flow of Arguments, and this award goes to the team Local Train. Participants of this team are Khushi Suratwala and Shubhi Mishra. Congratulations to this team. Last award, the last distinction award that we have is the Distinction Award for Best Time Management on both the issues. And this award goes to Team Blink 182. And the members of this team are Janvi and Muskan. So congratulations to this team, and congratulations to all the 5 teams who won the distinction awards. It's great that you guys are taking away some award from this moot court competition. The next award that we have is for Best Memorial. This team showed great skills in writing the written memorial and getting the first award in that component. This award also carries a cash prize with it, and the cash prize is of rupees 1,000. And the Best Memorial Award for the NLTI Moot Court Competition 2026 goes to Team Radiohead. And the team members of this team are Harkiran Kaur and Park Shui. They got the highest score in their memorial, and the score varied, and the score differed from the second ranked team by a lot. So there was a significant margin in the team winning Best Memorial. So congratulations on putting in such a good effort and making a very professional and formal memorial for this competition. Now, drum rolls, the winners of the NLTI Moot Court Competition 2026. So the final was just held over this stream itself, and the participants were the WHO versus the PCRC. Okay, any guesses? If any of you saw the live stream, just let me know in the chat box if you have any guesses on who will be taking away the title of the winners of the NLTI Moot Court Competition 2026. This title also carries with it a cash prize of rupees 1,200. Okay, I'm waiting for some responses. If I can get some guesses on who will be able to win this competition today, because I could see a lot of people watching this live stream. So if any of you want to take. Okay, so we have a couple of guesses. Let's see if they are right or wrong. So the winners of the NLTI Moot Court Competition 2026 are Team PCRC. Congratulations to Team PCRC. You guys did a wonderful job on all 3 fronts, that is time management, ability to answer questions, and your knowledge of laws and facts. Specifically, the speaker, Suyash Raj, he was also one of the best speakers in this competition. So congratulations to Suyash for showing such great skills, such great oratory and speaking skills. So PCRC is the winners of the NLTI Moot Court Competition 2026. So finally, you all know who the runners-up of the NLTI Moot Court Competition would be. So we have the Who as the runners-up of this competition, represented by Mahi Agrawal and Adar Pandey. They also have a cash prize of rupees 800. If I forgot to mention it here, but yes, there should have been written here as well. They have a cash prize of rupees 800. And yes, so that is it from this award ceremony. Thank you everyone for participating and making it a success. It means us a lot that you all participated in such high numbers with such great spirit and made this competition a success. Hope we were able to do justice to your expectations. Hope we were able to provide you with some experience, some courtroom experience before you start your law school journey. And I hope you will have some feedback or suggestions for us on how we can make this moot court competition an even bigger event next year. Thank you so much, everyone, for joining in. Thank you so much, and all the best for your law schools. Or if you are appearing for CLAT this year, all the best for your CLAT preparation. Thank you.